The fake redundancy. A workplace survival case file. They said his role was disappearing. What was really disappearing was anyone over 50. David had given the company 23 years, 2 decades of loyalty. Then a new director arrived, and suddenly experience became a liability. Within 4 months, he was made redundant, replaced by someone half his age, at half the salary. This is his story, and the £78,000 tribunal award that followed. David Morrison, 56 years old, senior financial analyst at a mid-sized manufacturing firm in Leeds. He joined the company in his early 30s, worked his way from accounts assistant to senior analyst. He knew every system, every supplier contract, every financial process the company relied on. When auditors had questions, they came to David. When the board needed projections, David built them. When the finance system was migrated in 2018, David led the project. His institutional knowledge was irreplaceable, or so he thought. Then the company appointed a new finance director. Rachel Simmons, 34 years old, MBA from a Russell Group university, a mandate to modernize. Her first act was restructuring the finance team. The first sign was the language. Digital transformation, agile finance, future-proofing the team. David had heard corporate jargon before, but this felt different. New software was introduced. David adapted. He completed every training module, passed every assessment. His proficiency scores were above average. It didn't matter. In meetings, his contributions were dismissed. He'd raise a point based on 20 years of experience, and the response was always the same. We're doing things differently now. Younger colleagues were promoted around him. People he'd trained were now his seniors. Then the comments started. Not aggressive, never aggressive, just pointed enough to land. Maybe it's time to think about what's next for you, David. Have you considered winding down? You've had a good run. The industry's changing fast. It's a young person's game now. David raised it informally with HR. He was told it was just clumsy management. Nothing to worry about. 3 weeks later, he was invited to a consultation meeting. Redundancy. The company said it was restructuring the finance function, that David's role, senior financial analyst, was being eliminated, that the work would be absorbed into a new position called finance data lead. David asked about the new role. Same department, same reporting line, 80% of the same responsibilities, but with added data visualization work. He asked to be considered for it. He had the experience. He'd done the training. He could learn the rest. His request was denied. He was told the new role required a fundamentally different skill set, that it wouldn't be appropriate to slot him in. The role was advertised externally 2 days after David's redundancy was confirmed. The person hired was 28. Less qualified, less experience, but cheaper, significantly cheaper. David was offered statutory redundancy pay, £8,000 for 23 years of service. Here's what makes this case legally devastating for the employer. In the UK, age is a protected characteristic under the Equality Act 2010. Direct age discrimination occurs when someone is treated less favourably because of their age. And unlike some forms of discrimination, the employer can defend age discrimination if they can show the treatment was a proportionate means of achieving a legitimate aim. But here's the thing. Replacing an experienced employee with a cheaper, younger alternative and calling it redundancy, that's not a legitimate aim. That's age discrimination dressed up in a business case. For a redundancy to be genuine, the work must actually disappear, not be renamed. not be repackaged. The work itself must cease to exist or significantly diminish. David's work didn't disappear. It was transferred to a rebranded role. That's not redundancy. That's replacement. And the selection process? For redundancy to be fair, the employer must use objective, non-discriminatory selection criteria. They must consult meaningfully with affected employees. They must consider suitable alternative employment. David's employer did none of this. They identified him, consulted him as a formality, and rejected his application for the replacement role without explanation. The comments about winding down and the industry being a young person's game? Those are direct evidence of age-related stereotyping. They show the decision-makers viewed David's age as a negative. David filed his claim. Automatic unfair dismissal and direct age discrimination. The employer's defense was textbook corporate denial. They claimed the restructure was genuine and commercially necessary, that the finance data-led role was substantially different from David's role. That age played no part in the decision. The tribunal wasn't convinced. The evidence was overwhelming. The roles were compared side by side. 80% overlap in responsibilities. Same reporting line. Same department. Same core function. The only significant differences were the job title and the salary. £32,000 compared to David's £51,000. The tribunal found the redundancy was not genuine. The role hadn't disappeared. It had been repackaged to justify replacing an expensive, older employee with a cheaper, younger one. The age-related comments were found to be evidence of discriminatory attitudes within the management team. The tribunal noted they reflected a culture that equated youth with capability and experience with obsolescence. David was awarded £78,000, £32,000 for financial loss, reflecting the difficulty of 56-year-old faces re-entering the job market. £35,000 for injury to feelings, £11,000 in pension loss. The tribunal also made a recommendation that the company review its restructuring processes and provide equality training to all managers. David's case teaches us 5 critical things. 1. Age discrimination is unlawful at every stage of employment. Recruitment, promotion, training, selection for redundancy, dismissal. You're protected whether you're 22 or 62. 2. A redundancy isn't genuine if the work continues under a different name. If your role is being replaced rather than removed, that's a dismissal, not a redundancy. The label doesn't matter. The substance does. 3. Casual, age-related comments are evidence, even if they're said with a smile, even if they're framed as friendly advice. Young person's game. Time to wind down. Think about what's next. These aren't throwaway remarks. They're admissions. 4. Cost-cutting by replacing older, more expensive workers with younger, cheaper ones is age discrimination. Salary reduction through generational replacement is not a legitimate business aim. 5. Challenge the selection process. Ask why you were selected. Ask to see the criteria. Ask why you weren't considered for alternative roles. If the answers don't stand up, the redundancy probably isn't genuine. Experience isn't a weakness. Age isn't a cost to be managed. If you suspect your redundancy isn't genuine, act quickly. Request the business case in writing. Ask to see the selection criteria. Ask why you haven't been considered for the replacement role. Document every conversation, every comment, every inconsistency. Raise a formal grievance before you leave. Put your concerns about age discrimination on the record. Then contact ACAS. Find a solicitor who specializes in age discrimination. Many offer free initial consultations. You have 3 months minus 1 day from your dismissal date to file a tribunal claim. The clock starts ticking immediately. 23 years of service deserves more than a manufactured goodbye. Subscribe for more case files. Real stories. Real outcomes. Real lessons. Know your rights. Use them.